This is ABC News legal analyst Royal Oakes welcoming you to Hinshaw Culbertson's Insurance Law Program, where we discuss insurance and reinsurance issues of interest to industry professionals. Here's your host, the co-chair of Hinshaw's Global Insurance Services Practice Group, Scott Seaman.
Thank you for joining us on Insurance Law. Social inflation was on steroids before the pandemic, but since the judicial system has gotten back to normal speed after slowdowns and cancellations of dockets, social inflation has really amped up, and nuclear verdicts have been rendered in increasing numbers. On this episode of Insurance Law, we'll take a fairly deep dive into social inflation, what social inflation is, the cost of social inflation, the things that are endemic in the U.S. civil justice system that makes it fairly susceptible to social inflation, the trends in society and litigation that are fueling social inflation. But most important, we'll discuss what insurers, policyholders, and their counsel must do to combat social inflation. There is a premium on prompt and proper evaluation of claims, knowing the judicial hellholes, settling those claims in cases that should be settled. But it's also important to challenge and to effectively litigate cases and claims that can't be resolved on reasonable terms, because the failure to combat social inflation increases the cost of insurance premiums, decreases the availability of insurance coverage. It increases the cost of goods and services throughout the economy and decreases the availability of goods and services. So it's incumbent upon claims and litigation professionals to deliver and to take those steps necessary to combat social inflation. So we're going to go into a presentation that we had given just a few weeks ago that looks at social inflation. So please stay tuned. Now, if you look at slide number 3, it's sort of an overview, and I'll say that we have had social inflation that spans my entire legal career going back to the mid-'80s. There was even some social inflation back in the mid to late 70s. We didn't have any before that because we didn't have the same product liability laws, the environmental laws, the mass tort claims, and the litigation environment that we have today. I think some of it's societal because in the old days, it seems looking back, society was a little bit different, less litigious. Maybe people weren't as greedy. Maybe there wasn't quite so much distrust in companies and institutions, and the divide between the political parties wasn't as great. And we certainly didn't have social media and the internet to allow views and people to gather and have things sort of proliferate. But it's mostly an issue, I think, of opportunity because basic human nature hasn't changed. So to start out by saying, what the hell is social inflation? I've seen probably 35 or 40 different definitions. Let me give you 3. Social inflation generally refers to the increasing cost of insurance claims, both on the indemnity and the defense side, resulting from societal and litigation trends, such things as litigation proclivities. And we see as a result large defense costs, large settlements, and nuclear jury awards in some cases. Back in the late 70s, Warren Buffett defined it as the broadening definition by society and juries of what is covered by insurance. And I would say mathematically, you could sort of view social inflation as the increase in claims cost above price level or economic inflation. So in my view of the world, there's 2 prongs to social inflation. The first involves the underlying claims or liabilities, the traditional challenges presented by the U.S. tort system. It impacts policyholders to the extent they are defendants and are uninsured or self-insured or underinsured or pay insurance premiums. But it impacts insurers insofar as insurers are on the hook for defense or indemnity. It largely reflects the abuse of the tort system, but in some ways, I look at it as being really just the use of a tort system that is slanted in favor of plaintiffs. In addressing the first prong, that's something that really requires joint efforts of policyholders and insurers, as well as their counsel to contain. We'll talk about that more later. Social inflation plays out differently in the 50 states, the 3,000 plus counties, and 94 US judicial districts. Not all jurisdictions are the same, and we're going to talk about some of the problematic jurisdictions later on. Now, the second prong is aimed directly at insurers. And this prong, the interest of insurers and policyholders diverge. This is the prong that deals with insurance coverage and extra contractual liability. It reflects such things as the broadening insurance policy interpretation that we see, the expanding scope of the duties to defend and indemnify, fee shifting and brand fee recoveries, time limit demands, which are used with increasing frequency today, the expanding scope of bad faith and extra contractual liability, the rising cost of independent counsel where they're required, consumer fraud and protection statutes in some states, such as the state of Washington, and claims handling regulations. We see it in, I think, the restatement of the law of liability insurance that came out a couple years ago, which was nothing more than a plaintiff's or policyholder's advocacy document. But so far that hasn't really changed things, hasn't really taken things to a high level because insurance law is a matter of state law, and most states do have some law. So there's not a lot of vacuums that need to be filled. The American Litigation Law Institute is in the middle of preparing their third restatement of tort law, which I think it's been since the 70s when the last one came out. And there's a chapter in there dealing with first party liability and bad faith. And we're going to keep an eye on that to see where that goes, because some things wrong with that. But we're not going to spend much time on the second prong today because each of these topics could be its own presentation. And this is an area that you guys are very familiar with. We did get, the only time in my career anyway, a reprieve from social inflation due to the pandemic and court closures and delays. But social inflation has returned with a vengeance, and some increases due to the backlog of cases, but there's really more to it. And if you look at slide 4, you'll see, if you could advance it, there we go. Large compensatory awards have been with us historically. And when I say that there are things built into the US legal system that makes it susceptible to social inflation, I'm talking about things like the availability of juries in civil cases is certainly a key component. But as we'll talk about it more later, judges are also responsible for a lot of social inflation and a lot of bad rulings that gives rise to large jury verdicts. The exposure to punitive and exemplary and other damages for some claims, class actions and multi-district litigation are rife for abuse by plaintiffs' lawyers, and these pieces of litigation are usually driven by plaintiffs' lawyers for the benefit of plaintiffs' lawyers, because generally they deal with suing en masse over things that it wouldn't be worthwhile for individuals to sue over. We also, of course, have a state of federal and state law and judiciary systems with sometimes different and conflicting procedural and substantive rules and laws, and that gives rise to opportunities for plaintiffs to forum shop. I would say there's a fundamental difference when you're a defendant versus when you're a plaintiff in the civil justice system. Plaintiffs can take their shot, but defendants have to contend with the dynamic that a ruling or discovery that's allowed in one case can impact or even bind them in other cases through res judicata and collateral estoppel. Similarly, policyholders have the freedom to take a position that they believe maximizes coverage. Insurers have to consider their portfolio interest in taking a position or before filing a brief, because as you know, some bad coverage law has been created when insurers take positions based on a particular claim, may help them in that claim, but isn't necessarily good for their overall portfolio interest. All the extensive pretrial discovery in the U.S., which is we don't see to the same extent in other countries. And a lot of times the complaint is too much costly discovery that increases defense cost, and it increases indemnity exposures by allowing plaintiffs to go fishing. But a lot of times the problem is that defendants and insurers are denied appropriate discovery. And of course, there are large legal costs that extend beyond discovery. In our country, the American rule on attorney's fees is that each side pays its own fees as opposed to the loser pay rules in the UK. It works generally against defendants. The fee shifting statutes that accept the American rule traditionally favor plaintiffs in the underlying litigation and policyholders in coverage litigation. And of course, the tradition of plaintiffs' lawyers taking bodily injury cases on a contingency fee basis does contribute to the number of cases out there. And we all know about junk science and lax evidentiary standards, particularly where it comes to expert witnesses. So we see tort reform that's really, these efforts have been continuous, but with mixed results. Some efforts have been successful in some states on some issues, but it's a challenge getting meaningful tort reform through state legislative bodies. And sometimes even when you succeed in doing that, you'll see state Supreme Court striking it down on state constitutional grounds. There's a limited role for the federal government on state tort claims. There have been some helpful preemption rulings that in fact impact smaller aspects of some types of claims. Now, when Congress went ahead and passed the asbestos bankruptcy law, providing for 524G channeling injunctions, the intent may have been to provide relief, but the effect of that has been really to give rise to numerous claims and be a fast track for massive payouts. So let's go to slide number 5. And we're actually going to spend a little bit of time on this slide because I've got some points that I want to drill down on because this is really the heart of our presentation. One of the game changers has been litigation funding. Litigation funding used to be barred widely in the United States under the doctrine of champerty, or sometimes called maintenance, which generally precluded strangers to a lawsuit from funding litigation fees and costs in exchange for getting financial interest in the case. But litigation funding has gained traction in many states over the past couple of decades, have either limited or watered down those laws. The surge in litigation funding recently has been a tremendous boon for plaintiffs' lawyers. It has increased the volume of cases that are being pursued. It's enhanced the ability of plaintiffs to take cases further and pursue larger recoveries, extending the litigation timeline, increasing the cost of defending a case, and increasing the potential for larger verdicts and settlements. And it's enabled plaintiffs to invest in more experts, what I'll say so-called research and studies, and other weapons to deploy against the defendants. Because of the larger awards we're seeing in the justice system these days, litigation funders are finding it easy to justify investing more greatly in litigation funding. And this allows these already creative plaintiffs' lawyers to run even more wild in the civil tort system. Now, although we've had, as we talked about, contingent fees for a long time, with that at least, presumably there was some incentive for plaintiffs' lawyers not to take meritless cases or spend time on cases that weren't able to produce a recovery. And we're seeing the impact of litigation funding, meaning not only are good cases, dangerous cases for defendants getting larger settlements, we're even seeing more mediocre cases getting larger settlements. I would say that there's some different reports on how big the litigation funding game is. Swiss Re concluded that it was about $19 billion worldwide in 2020, and about half of that was in the US. Bloomberg referenced the size of the litigation funding sectors being $39 million back in 2019. And then I saw something, one of my partners showed me something yesterday from Reuters talking about 3.2 billion, but saying that there are about 44 active litigation funders in the US market, and they have a total of 13.5 billion in assets that they're managing, and that had increased in 2022 by 9%. However, whatever that number is, it is large, it is growing, and of course, not all of it is financing personal injury cases. Now, some states have enacted legislation addressing litigation funding, requiring registration or disclosure or licensure, imposing more stringent requirements of disclosure, in the absence of which there would be no disclosure requirements, or regulating interest rates. But most states have done little, not enough, or nothing on it. The main focus of the defense bar has been to require financial disclosure of litigation funding. Court decisions on disclosure have been mixed, with some courts saying yes, some courts denying disclosure of discovery of litigation funding, saying it's either not relevant or it's privileged. A couple of courts have orders that require disclosure of litigation funding. I think litigation may be an important first step, but it's not enough to deal with the issue of litigation funding. Now, we've seen that litigation funding and funders can be very active in promoting plaintiffs' litigation. In fact, I think it was last week that a litigation funder was sentenced to 3 years in prison for his part in a $30 million litigation scam that involved staged trip and fall cases and unnecessary surgeries and fraudulent lawsuits. And this week, some of the lawyers and experts got sentenced as well. Litigation funders are finding it to be so profitable that they're trying to make it worse. Some are now engaged in efforts to take ownership in law firms. An ABA rule of professional responsibility 5.4, and it's rare that I'm able to get these numbers right, precludes this. It protects a client's right to confidentiality. It preserves the exercise of a lawyer's independent judgment and ensures that client representations are conducted by those qualified to do it and bound by ethical rules. But litigation funders are lobbying and they're engaged in efforts to end these restrictions, and these are things that need to be opposed. I have to say, insurers are victimized, of course, by social inflation, and insurers play a big role in providing solutions to controlling or containing it. But there's one way I think insurers as a whole may have contributed to social inflation, and in particular, nuclear verdicts. You have to give the devil its due. Plaintiffs, the bar has always been creative and resourceful and had that advantage. But corporate defendants used to enjoy a budgetary and leverage advantage in litigation, and that's not the case anymore. While plaintiffs are investing in achieving bigger verdicts and settlements, investing in scientific research and experts, many corporate defendants and their insurers have relinquished this budgetary and leverage advantage to the plaintiff's bar, at times by what I'll call a myopic focus on reducing or limiting defense expenditures. And the need to control defense cost, of course, is undeniable. You get no argument from me on that. But perhaps I'm suggesting the pendulum has swung too far and too much attention has been focused on attorney hourly rates, excuse me, legal fees, audits, and appeals. But it is a concern across the industry where some companies have really devoted so much attention to that and restricted defense efforts where it is impacting the ability to properly prepare cases. What I am concerned about, though, as a practice leader, is the long-term impact on the legal talent pool. There are concerns about the ability of defense firms to compete against plaintiffs' firms and other corporate practice areas for top legal talent long term. Millennial and Generation Z lawyers are less receptive, it seems, to being tied to tracking billables and complying with litigation, billing guidelines, responding to audits. For that matter, they're less inclined to want to pay their bills, their dues. They want to come in and sort of take over a firm or take over a company the moment they get there and want a seat at the table. Again, I would say that the defense bar is losing talent. And that is a little bit of a concern and something I think we all need to be focused on going forward. Let's go on with some of the other drivers of social inflation. And you'll see, and that attorney advertising is a very valuable recruiting tool for plaintiffs' counsel, and they've used it masterfully. Advertising not only produces more plaintiffs, it produces better plaintiffs, and it increases the expectation on the part of plaintiffs of a greater recovery. According to the American Tort Reform Association, the plaintiffs' trial bar has spent approximately $6.8 billion in advertising from 2017 to 2021, about $1.4 billion in 2021 alone. That's a lot of money. And in 2021, there were about 15 million ads on local TV, tens of thousands on national cable. And when you add that to billboards and radio advertising, that's a lot of money and a lot of messaging bombarding people. Advertising is more than a recruitment tool for specific cases or even types of cases. It provides plaintiff-oriented messaging that impacts society more broadly. And we use voir dire not only to obtain information about prospective jurors, but to condition them to our theory of the case. But plaintiffs have essentially now launched a multi-billion-dollar campaign to condition prospective jurors and give them pro-plaintiff, anti-defendant mindsets even before they become jurors. And I ask all of you, when was the last time that you saw a public service message about the danger and unfairness of faulty assignment of blame or the cost of excessive jury awards resulting in higher product prices and less products being available? You just don't see very much of that. And that's an area that I think the defense side of the equation has to work on. Today, all claimants are lawyering up. The days of being able to settle a claim, even a relatively small claim, directly with a plaintiff, seem to be gone. There's few opportunities to do that. And that means you get plaintiffs' lawyers involved earlier and more often, and that's increasing the cost of claims. We talk a lot about anti-corporate, anti-insurer, anti-institutional sentiment. Look, that's always been the case, and plaintiffs have always exploited it. But I think the residuals from the financial crisis of 2008, Occupy Wall Street, Me Too, some of the protests have really amped up the bad feelings and mistrust about companies and institutions. And then you have to add to that technology, social media, the internet, which provides a platform for users to gather and complain and organize and for a negative public sentiment about companies to proliferate. And that's playing a role in some of the large verdicts we're seeing. If you look at me, you can appreciate I'm not political at all, but I would be remiss if I didn't at least point out that political discourse and political views impact the mindset of jurors. With all the media and social media, political ideology being a part of daily discourse, it's out there, it makes its way into the jury room. We're living in a society where beliefs often prevail over facts, and where there's a good deal of tolerance for the notion of people having their own truth. And this impacts civil litigation. The normalization of nuclear verdicts is a driver of social inflation. We're going to talk about that more later. But another problem that we're having is the expanding liability and disappearing defenses. So for example, since 2002, about 17 states have revised or eliminated statutes of limitation for sexual abuse cases. In fact, earlier this month, Maryland, that had done it several years ago, upped the age for alleged abusers to bring claims, has now eliminated the statute of limitations for childhood claims, at least at the hands of institutions. The Illinois Biometric Information Privacy Act has been an example of nuclear legislation that's creating mega liability. So that's legislative induced social inflation. And then the Illinois Supreme Court recently ruled that a claim accrues each time biometric information is collected or disclosed, putting a judicial imprimatur on social inflation. And then, of course, you've got public nuisance in some places like California being a problem and leading to some large liabilities. So we see that stuff taking place. And then we see governmental entities piling on in favor of plaintiffs. I mean, aggressive investigations of companies and the dissemination of that information by leaks and reports does create evidence for plaintiffs. But one of the most egregious examples of aggressive government action is the National Association of Attorneys General, that used to be a coordinating organization, but now they are coordinating and working with the plaintiff's bar and seeking and obtaining recovery in tort cases, such as in opioids and tobacco litigation. And for example, they received $15 million out of the McKinsey opioid settlement from a year and a half ago. So that's really brings into question, the role of government and, when they become aligned directly with the plaintiff's bar. So on slide number 5, you also see, a lot of these points relate to the younger population. You can see by taking a look at me that I'm old, but that I'm not old enough to be part of the greatest generation. At least I'm not good enough. I'm a baby boomer. And as a trial lawyer and litigator, I have to remain young at heart. I have to at least understand the mindset of millennials and Generation Z people, know what they think, how they think, whether I agree with it or I disagree with it, because I have to manage younger lawyers and I have to understand younger jurors and craft arguments and shape cases to appeal to them. And I think that's one area that overall the defense bar and even coverage lawyers have lagged behind the plaintiff's bar and policyholder lawyers. The reality is that the number and the percentage of younger jurors, younger workers, and younger managers are increasing, and the plaintiff's bar has done a much better job at appealing to them. The case in point would be reptilian strategy or theory, which has been effectively employed by the plaintiff's bar and really does have appeal to younger jurors in many cases. A 2021 study by one of the trial consultant groups found that 84% of the 3,500 prospective jurors across the country they interviewed agreed with the notion that they need to be guardians of the community by forcing companies to change bad behavior with large damage awards. Now, let's face it, it's not music to defendants' ears, and it does chime directly into what plaintiffs are trying to achieve with reptilian theory. With technology, social media, iPhones, and the internet, it impacts how jurors receive information and use information in some profound ways. One time we're of a situation where right in the middle of an argument of jurors were seen Googling or fact-checking by Google an argument the counsel was making. So we need to be cognizant of that. We see with increasing frequency, the ability to page merging into liability determinations. They're a company, they can afford to pay. There's social justice in making them pay. We see with increasing frequency, punishment invading the province of compensatory awards. One study found 37% of juror respondents strongly agreed that the primary purpose of damages was to punish defendants rather than compensate plaintiffs. And 44% somewhat agreed with that. Punishment might be a consideration in appropriate punitive damage claims, but it should play no role whatsoever in our civil justice system with respect to liability, compensatory damages. More and more jury instructions are being followed less and less. And fairness in our jury system depends upon jurors following the judge's instructions. There was a study a couple years ago that found 57% of prospective jurors would ignore judge's instructions to avoid internet research. 52% would not take time to look at the jury instructions if they thought they knew the case. And 75% would disregard the judge's instructions to ignore inadmissible testimony if they believe the testimony. So it's important to sort of understand and glean some generalizations about the different generations. But at the same time, you have to realize that people are individuals and the juror dynamics take on a different flavor when different generations are combined into a jury pool. We're going to skip over slide 6. I spoke about those elements earlier, and we're not going to really get into them further. On slide 7, we say it is difficult to nail down exactly the cost of social inflation, but we do give some indicators. We talk about the U.S. Chamber of Commerce report on 2020, where tort costs were $445 billion, or represented 2.1% of GDP, and from 1960 to 2016, and be a long time if we went back to the 1900s, to 2020, the direct cost of the tort system grew at a pace of 6% a year in excess of inflation, which was 1.9% a year. And the estimated cost equated to over $3,600 per household. And you see the consumer price index rose 10.5% from 2017 to 2021, while property and casualty incurred losses increased more than 57% during that same period. And you see payouts on commercial auto insurance lines, $20 billion between 2010 and 2019, 14% more than social inflation. You can see some other numbers there, but I think the key to it all is that it is impacting multiple lines of coverage, from general liability, commercial auto, med mal, professional liability of various types, D&O, and umbrella and excess coverage. We talked about nuclear verdicts as being, and the fact that they're being normalized, that contributes to social inflation. But in some ways, nuclear verdicts also are a measure of social inflation. And so nuclear verdicts are verdicts over 10 million, and thermonuclear verdicts are verdicts over 100 million. And in the white paper that we're glad to provide you, we cite to several studies, including a Marathon Strategies study that did analysis of nuclear verdicts. And some of the reports on nuclear verdicts and on problematic jurisdictions that we'll get to provide a lot more detailed information and breakdowns than we're going to have a chance to talk about today. But generally, the $10 million number is the number used to characterize something as a nuclear verdict. But, counting something as a nuclear verdict doesn't mean it was a runaway verdict. You obviously need to know the facts and the causes of action and the damages to assess the fairness of a verdict. But overall, using it does tell the story, it does a good job generally painting the picture. These studies generally don't take into account then post-trial relief or appellate relief. But you can see that between 2009 and 2022, in state courts, there were 578 nuclear verdicts and 304 in federal court. Yet the median nuclear verdict size was about 18 million higher in federal court. But I think that's largely a function of the types of cases being tried. If you look at slide number 9, it gives you sort of a illustration of the states that have the top number or the highest number of nuclear verdicts from that period of 2009 to 2022. And you'll see later that there's a large correlation between those states and states that are characterized as problematic jurisdictions or by some as judicial hellholes. Slide 9 provides an annual breakout. Slide 10 shows you, it gives you a little dichotomy. The first group of years are the years following the Great Recession or the financial collapse in 2008. And then the next group sort of shows the activity leading up to COVID-19. Go to the next slide. And this gives you an annual breakdown, numbers and totals of nuclear verdicts. We're not going to spend much time on that. I think slide 12 is a little bit more interesting because it provides a breakdown based upon subject matter of the case or legal theory. And you'll see products, intellectual property, breach of fiduciary cases, top the list. And with respect to products, pretty mightily. And you'll see the various causes of action. And that's probably worth giving a little bit of analysis to, depending upon the lines of coverage that you're involved in. On slides 13 and 14, we talk about problematic jurisdictions. We have more information on this in more detail in the white paper, but these are the jurisdictions that are the superhighways to social inflation. Cases in these jurisdictions usually warrant greater attention, but as you know, any case, no matter where it's pending, can be problematic and result in a large verdict. But it happens time and time again in these jurisdictions, and plaintiffs seek out these jurisdictions whenever they're able to do it. I will say, if you look at slide 13, you've got a pretty good breakdown by rankings of jurisdictions. Slide 14 shows, this is based on a report that just came out a couple months ago from the American Tort Reform Association, and it characterizes jurisdictions as judicial hellholes, as jurisdictions being on the watch list, and dishonorable mentions. And obviously you need to take into account the jurisdiction for choice of law reasons, but also in evaluating the claims and maybe in coming up with your strategy to resolve a case. But I think slides 15 and 16 are a little bit more important because they are talking about what factors are associated with a jurisdiction being problematic. The most important factor leading to that status are bad judges. As I say, we focus a lot on nuclear verdicts, but we need to also focus on nuclear court rulings and nuclear legislation because they give rise to nuclear verdicts. The age and the politics of the judiciary are changing. Some jurisdictions are known for more activism, being more plaintiff oriented. Quality of rulings varies from jurisdiction to jurisdiction and of course from judge to judge. But many of the same social factors we talked about before, the societal factors, are impacting the composition and the views of judges as they are the impact of the jury. So we could give you examples of some of them earlier, I think, on nuclear rulings and legislation. But defendants in the problematic jurisdictions are targeted based on deep pockets rather than culpability. Extraordinary verdicts are upheld more often, even when they're not supported by evidence or when they sometimes violate constitutional standards. Cases proceed where the parties or the events have little or no connection to the forum, and forum shopping is allowed, and that's actually one of the hallmarks of a problematic jurisdiction is they let plaintiffs in and don't let defendants out. There's a lot more discovery abuses. There's a lot more consolidation, even timing, allowing plaintiffs control over, what cases go to trial when and in what groups. Classes that should not be certified are certified. Improper slanted jury instructions, which are destructive, are given. Judges facilitate and sustain these excess verdicts. They allow for novel damage theories, everything for hedonic damages to, companionship damages we've seen in animal injury cases, emotional harm damages. So it's a lot of things that result in a jurisdiction being characterized as a problematic jurisdiction, and our report goes into greater depth on that. But we find ourselves really, as we go into slide number 16, facing the triple barrel of social inflation, economic inflation, and greenflation. And until last year, economic inflation had not been a major issue in the US for decades. Last year, inflation reached a 40-year high, 9%. I think in March, it was about 5%. Going back to February, it was 6%, but still all a great deal above the 1.5% we've seen in prior years. So price level inflation naturally increases a cost across the board, across all industries, increases defense cost as well as indemnity. It presents claims and underwriting and reinsurance and even operations challenges to jurors. Standing alone, it increases the resolution cost of claims, but I think you have some synergistic effects. Just as we talk about normalization of nuclear verdicts, we have jurors going in to the jury room with keen awareness of prices rising, and maybe with notions that they've got to make up for that with larger verdict awards. And if you are so they do, it does impact jury awards. And I also am going to suggest, and there's no proof of this yet, I'm going to apply John Keyes' economic theory that he used to say wages and prices were sticky downward. My theory is that jury verdict awards will prove to be sticky downward, that with economic inflation going up, jury awards will go up, but you won't see a swift or as deep a decline in verdict numbers when price levels go back. In terms of sustainability, greenflation is worth discussing, but it's not additive to economic inflation. It's part of the numbers that we see with the various indexes. There's a lot to be said about ESG and sustainability, but we're going to limit our focus here. I will say that the pace, the breadth, the depth of ESG is the result of several things led by the all-of-government approach that the Biden administration and several states are taking. But the younger workforce and the increasing numbers of younger generations in management is altering the equation, because companies traditionally would be more of a resisting factor to some of the changes that we're seeing taking place so quickly. But many of those companies are actually proponents of a larger level of change, due in part to pressures from a younger workforce and more managers supporting change. ESG is generating a host of new claims and claim types, such as greenwashing claims, D&O claims relating to environmental issues and misrepresentations, environmental claims based on company performance, government claims relating to board composition, S claims relating to ESG and other issues. So that's at play. And when you factor that into social inflation, it's really a very dynamic and challenging atmosphere. The other thing is the talent pool, the great resignation, the great attribution, as it's called, is further changing the composition of the workforce. And it's making it harder for all industries to find people that are eager to join and eager to sort of bring new skills to the table, but they bring different approaches as well. And I think the insurance industry is facing challenges in attracting and keeping younger talent. So, it's the laws of physics. For every action, there's an equal and opposite reaction. I'm not sure Sir Thomas Newton would be completely accurate here, because I don't think the anti-ESG activities are equal, but we are seeing more and more ESG activities. And from an underwriting perspective, obviously, and risk management, companies, have an appreciation that in policyholders that are ESG aware and have good practices with regard to ESG are better risk. But some caution has to be exercised, because ESG activism can also produce claims and present issues. We've seen some of that stuff with Disney, Bud Light, Ben & Jerry's ice cream, and so forth. So this is the post-pandemic era, slide 18. And we know that court closures and litigation slowdowns were a short-term social inflation reducing factor, with bench trials dropping 39%, jury trials going down 64% in 2020. And in some cases, justice delayed did equate to justice achieved, where plaintiffs, we've seen in some matters, knowing that there would be long delays, became a little more reasonable or less unreasonable in their settlement demands. But coverage cases on COVID-19, the first-party business interruption losses have gone, quite well for insurers in the U.S. I think probably better than most types of massive coverage litigations have gone. If that's something you're interested in, we've got materials that really drill down on that. And we saw that while a lot of proposals were put forth in state legislative bodies to effectively water down the requirement of direct physical injury, or to legislate away exclusions, none of them became law. So in that sense, COVID-19 did not directly contribute to social inflation. I think we've got to realize that many jurors have been changed by the pandemic, either being sick themselves or having relatives sick or injured. And there's going to be some fallout in terms of juror sympathy for personal injury plaintiffs that I think we're going to have to contend with. And remote proceedings, while not as common as during court closures, I think we're going to see them continue to some extent because of convenience, because of cost control, and because of people viewing that as a way of controlling their carbon footprints. Just in terms of, we've got the Marathon Strategies report shows, a rise in nuclear verdicts after courts started to reopen. You can look at some of that information if that's of interest to you. I want to spend a few minutes, though, talking about what insurers and companies are doing and should do to control social inflation. I think there's a three-barrel approach that's required. The first is, the tort and legislative reform and judicial reform aspect. Insurers are and have to educate and train their own personnel. They have to educate policyholders on social inflation. I think we're seeing insurers working more closely with policyholders to employ more cogent loss control, safety, on best practices to avoid and limit liability, on documentation to limit liability, to support defensive cases, and to give plaintiffs less fodder in their pursuit of large awards through reptilian theory. Working together with counsel and policyholders, insurers, of course, need to monitor and get involved in lobbying legislative and judicial developments, and continue fighting the battle for tort reform. We've seen some good examples, tort reform in Texas, that impacted what was really out of control truck accident claims. We've seen two waves of tort control and tort legislation in Florida in December of last year, and then this past month. We could talk about some of it that we do in our paper in greater detail, but that is meaningful tort reform. Of course, there's also been a surge in new filings in Florida, over 200,000 new filings in March to get ahead of the effective date of that legislation. And if you're interested, we cite to a publication with over 100 ideas on tort reform, but working on tort reform, tort rules, court rules. And a lot of states are in the midst of jury instruction initiatives. And it's important. We've talked about jurors not following it. So if they don't read it, they don't listen to it. Whatever you write by way of instructions may not be a panacea, but it is important to continue working on that because the plaintiff's bar will not. And we really need to counter the billions in messaging the plaintiff's bar has out there. In terms of, what insurers are doing in their offices, if you will, on the underwriting side, the same old tried and true things of exercising underwriting discipline, looking at risk more closely with social inflation factors in mind, adjusting premiums to account for it, altering limits, sometimes lowering them or sometimes increasing or indexing them to provide policies that have utility to their policyholders. You see revisions to policy terms and conditions, some exclusions, but not just to cover what we're seeing in the tort area, but based on things we're seeing in coverage litigation, based, for example, changes on independent counsel and limitations on fees and what sort of fees insurers are required. You really have to keep up with developments, though it's lagging, usually on the policy content side. On the claim side, things that we're going to talk about on reptilian theory control will apply, but both on the underwriting claim side, using AI is important to get quicker and more accurate information, to be able to evaluate data more accurately and more quickly. Hiring and training outstanding talent. You really have to, I think, put an emphasis when you're looking at counsel and experts that you're dealing with people who are agile in dealing with times, limits, demands, who know what's going on in the underlying tort area, as well as coverage issues, counsel that can assist you in evaluating claims, and counsel that has guts. I mean, yes, we have to give you the best counsel we can in terms of evaluating claims, but we cannot afford to play Santa Claus. We cannot afford to give away the shop because of concerns. We have to really focus on claims that actually present high risk, and we have to get in front of those claims early. We have to use jury research, not just mock trials, but jury research to test our theories of the case, specific evidence. And we have to really vigorously and cogently defend cases, evaluate and settle the ones that we should settle, but be prepared to fight and try the ones that we should fight. And we have to really adjust ourselves to this changing environment. And if you go ahead to slide 21, yes, we've got all these dynamics of social inflation. We have to update and follow, but not usually abandon some of the cogent things we've done. In other words, the proper maintenance and documentation of claim files, keeping in mind the lessons we've learned from bad faith generally, from institutional bad faith, procedural bad faith, understand and protect our portfolio interests throughout, because social inflation doesn't always change things. Sometimes it just magnifies things. But really, we have to keep the faith. It has been the talented people in claims and underwriting and other folks in the insurance industry that has guided us through really a continuous flow of challenging claims, changing price levels. And you guys are really the solution. I have great confidence in the men and women in the insurance industry. And it's critically important because our economy depends upon it. Just for a couple minutes, we'll talk on slide 22, I think it is, on reptilian theory. Again, we'll send you a couple papers if you want them. We talk about this in greater depth in the white paper, but reptilian theory really asked jurors to consider the interest in safety, the interest of society and safety, to be guardians of safety for society. It's been out there for about 15 years, and it's really been a genius way for plaintiffs to attempt to circulate traditional rules of evidence that would bar arguments in evidence and to make arguments that would be barred as being improper. It's calculated to trigger the reptilian brain in jurors, focus them in safety over legal issues, ability to pay over fault, a punishment above mere compensation, and defendants really caught off guard for many years by this, starting to catch up, largely catched up. But again, prompt case identification, evaluation, critical. We need to put a dollar value on cases as soon as we can, update them. We need proper post-mortem analysis of cases, but we really have to be proactive. All of the tools we've used as trial lawyers for years, motions in limine, motions to strike, motions for protective order, and keeping out this reptilian evidence. But we have to be prepared where reptilian evidence is allowed to be put in, that our witnesses are prepared to address those questions that they're going to get, and that we're putting an affirmative case about the good things and the goodness of companies, put things down at the level of the individuals, and put jurors in their shoes, and point out to jurors the flaws of what would happen if companies did, or if this plaintiff did what the plaintiffs allege that they should have done. We have to explain our reasoning on state and safety, utility of our actions, and really paint an affirmative picture of companies in the defense. And a lot of times you can use reptilian theory right back at the plaintiffs by pointing out to the jurors what the adverse consequences would be. And again, always bringing them back to the facts of the case, what happened in this case, and their obligation to render verdicts in a particular case. So one final point on that anchoring. There's been a reluctance historically of defendants to talk about damages or put a lot of time on it, thinking, well, that's conceding liability. You cannot afford to ignore damages. You have to vigorously seek discovery on damages, make your case against damages, and present do some anchoring on damages. Put out there that if you find there is liability, the damages should only be this. Plaintiffs have anchored for a long time, but the old school of many plaintiffs' counsel saying, well, we'll just put it out there and won't ask for a specific number. Now they ask for as large a number as they possibly can. Well, I would like to say that's social inflation in a nutshell, but it is a fairly detailed discussion of many of the aspects of social inflation, something we will continue to watch, monitor, and develop strategies to combat. We thank you for joining us and look forward to seeing you on the next episode of Insurance Law.
The information on our insurance law program is provided for general information purposes only. Nothing stated on the program constitutes legal advice or creates an attorney-client relationship. You should consult directly with an attorney of your choosing if you'd like to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. For information on past and upcoming programs, visit the Insurance and Reinsurance page on www.hinshawlaw.com and click on Multimedia.